Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts, and today I'm psyched to be joined by Patrick Sullivan, a partner at Dallas Hartman's office. Patrick, thanks for being here today, man.
Of course, happy to be here.
Yeah, so I knew of you, but Dallas Hartman's, you guys are a little up north from where I am, and I don't leave the confines of my office or a courtroom if I don't have to. So I don't think that we've crossed paths too many times, but I was in trial recently and my trial operator was Diadigo.
Good guy.
And Diadigo's the best. And we, of course, were talking trial stuff, and I'm always picking his brain about, what different cases has he sat through. And he was telling me about your recent verdict in the Malvar case, which I had read about on the listservs and had been meaning to reach out to you anyway. But, Matt was just, telling me what a kick-butt job you did on a really tough case, which we're going to hear, the needle that you had to thread to pull off this terrific verdict today. But I, was looking for the intro, and Matt gave me your number, and I texted you, and you're probably like, who the hell is this dude? But I appreciate you being here to talk about this case and how you accomplished this verdict.
Well, I appreciate it. I appreciate Diadigo, telling you some lies about how I threaded the needle to get this verdict. But no, he's a heck of an operator. He is. So appreciate him every time I have him on a case.
Yeah. And, for those who don't know who we're talking about, it's Matt Diadigo, who is, for guys like me and Patrick, our, go-to trial operator to, do everything from calling our exhibits up to arranging our evidence and giving us insights at trial and being an all-around good dude. Patrick, I was curious a little bit about your background. So I know you're a partner at Dallas Hartman's office, but tell me a little bit about your sort of, path to becoming a trial lawyer. You obviously have a love of it. What was your journey from law school to getting to where you are today?
Well, it was actually pretty simple because when I went to law school, I have no family members that are lawyers, anything like that. So in my picture, a lawyer was a litigator. So I just always wanted to be a litigator, do litigation. So I did a bunch of that when I was in law school, the trial advocacy program and teams and whatnot, and those competitions. And then when I started looking for jobs, I was just looking for litigation jobs. But back then, all I knew about was criminal work. So I worked for a bunch of different criminal firms when I was in law school. And then when I was applying for jobs, I saw a civil litigation firm that was hiring. I had no idea what civil litigation was. I just knew that it was litigation. So I applied for it, got the job. And then that's what I've been doing ever since. I mean, fortunately, by the graces of God, I got hired by a plaintiff's firm. So I've been doing plaintiff's work my entire career. Wouldn't have it any other way. I know a lot of people start on the defense and they say, hey, it's important to get some defense work for the defense insurance industry. I'm sure it's advantageous for some people and some people need that experience. But in my experience, it hasn't been necessary and it's worked out well for me.
Yeah, I'm in the same boat as you. Always 100% pure plaintiff lawyer. Yeah, I mean,
Since
there's
day
definitely,
one.
there's certainly that sort of curiosity of, pulling back the curtain. Had I worked on the insurance defense side at one point just to get the lay of the land, but then I think to myself, nah, I'm good. I don't think I need that experience. But, over the years, I mean, now you're pulling off some really tremendous verdicts. And in my experience, usually people are not just kind of like out of the box hitting those kind of verdicts. So, what did you do over the years to, educate you, and what do you look back and feel like, these were either the people or the seminars, the trial lawyers, or the books that kind of influenced you a lot?
Well, like you said, you don't just come out of the box and you're a good trial attorney. I think anybody that acts like that is full of BS. But, the one thing that's great about this is you continually learn. If you think you got it figured out, you think you know everything, I think that's when you're going to lose a case that you should win. So just continuing to learn. I mean, even up to this point. So with that, I think the big thing is jumping in and doing trials, which is hard to come by now. You know that as well as I do. So, you don't just walk in and get a great verdict your first trial. I mean, look, some people have, but I think that's few and far between. There are a lot of losses along the way in developing your trial skills. I mean, trying everything, garbage cases. I've heard people refer to them as dog shit cases, the motor vehicle crash, rear ender with no property damage and 4 prior crashes. Hey, raised my hand in my first firm. I'll take that one to trial, not knowing any better. But I did my first trial probably couple months after I got my law license, which, I mean, as well as I do, a lot of attorneys of my age and your age, I know some that haven't even been in trial yet, and call themselves trial attorneys. So I don't know how that works. You might do 1,000 depositions, but it's a lot different than getting in court and doing a trial. So there are a lot of losses along the way, but number one, you got to get in the arena, any way you can. And even doing arbitrations or doing, administrative hearings, whether it's workers' comp, social security, those things, they give you, an opportunity to do a direct exam, cross exam, but nothing's like a jury trial. I mean, you know that. So you got to get in and do jury trials. So that's a big part of it. I've tried to do as many of those as I can through my career. But a lot of times the insurance industry is dictating when you can and can't, but sometimes you got to turn down a good offer and take it to trial if you got the right client to do it and the right case to do it. The other thing is just constantly trying to learn. So as you said, seminars, things of that nature. So all the greats out there. I mean, everything I do in trial, I'm sure with you and other attorneys, we don't create it all. We don't make it up. I mean, you put your own touch on it, your own little twist on it. You got to be yourself and authentic when you're in trial. And I think, look, I'm myself and I can't do what you do. I can't do what the Nick Rileys of the world do, the Keith Mitnicks. I don't talk like them, so I got to keep it to my own style, my own flavor, whatever it may be. But a lot of the strategies, the tips that you can learn from reading their books. I mean, I'm still reading their books, and when I go to trial, I got a stack of books in my war room, and all the books, all the same books. I got them all sitting there.
I got them here.
Like,
Look.
oh, yep.
Where is it? Oh, wait.
There you go.
There you go.
I recognize a lot of those. Oh, yeah. Yep. And I haven't even been through all of them yet, which is great. So I'm still reading, still learning. But those are the biggest influences, figuring out how these other guys are getting these great verdicts. And again, it all doesn't apply to me or it all doesn't apply to every case. But if I can take a little bit out of, trial by human, take a little bit out of don't eat the bruises, different things like that and applying to my case, my trial, my style, hey, that's great. So, those two things, being willing to learn, don't stop learning. Number two, get in the arena. You got to get in the arena. I mean, there's nothing like the pressure of being in trial, and number three, and I think most trial attorneys have it, you got to care about your clients. And like a lot of that comes with passion, right? Be passionate about what you do, but I think even more so than that, it's being passionate about your clients. The title of your podcast here, Just Verdicts, right? You're doing just verdicts for just people. And you got to know, like some cases you get that come in the door are not good cases. They're not the right cases. Don't try those cases. But other ones need to be heard. In this particular trial, needed to be heard, even with all the complications of it against this particular defendant that we ultimately took it to trial against. My client wanted to be heard. She needed to be heard. And I think it did her a lot of good that we took it to trial, even if we didn't win. It would have done her some good. Thank God we did win, though, but all those things. And, my boss, former boss, Dallas, right? I'm sure you're a little familiar with Dallas. He's a different guy.
Everybody knows Dallas.
Successful attorney.
Yeah.
Very tough boss, very tough mentor. But one of the things that, kind of drew me to him, and I think why we get along, is regardless, he's very different from me. But nevertheless, like, he cared a lot about his clients. And that was a big thing. I mean, I remember little thing conversations of, hey, this person doesn't have income right now. Do you know what that's like? Have you experienced that? Look, most attorneys haven't. I have. I'm familiar with that. So that's a little different. But when you think about it that way, or like here, my client, a widow, right? She was essentially a homemaker her whole life. She did go back to work. She was working in the school district, maybe making like $10 an hour, working a few hours a week. But her husband was the breadwinner their entire lives. This guy dies unexpectedly and suddenly. Her world is upside down. She doesn't know how she's going to pay the mortgage, doesn't know how she's going to pay for the kids going to college, how she's going to pay for groceries, etc. So, any attorneys out there, especially young ones, I tell them, keep that in mind. It's easy. We get so deep in what we're doing, right? and our strategy, our presentation, our depositions, the case itself, you can't forget about who you're doing it for, right? And that's extremely important.
Patrick, you just, dropped so much good stuff right there that as you were saying it, I'm like, oh, I want to ask him about this. I want to ask him about that. And I'm not going to remember everything that you just covered, but I want to hit a couple of things before, we pivot into the case that you've already begun to tee up. You talked a little bit ago about those dog type cases, those rough
Right.
cases, the far from perfect when you're first starting out to get into the arena, as you put it, to get into court, and you said, hey, that case, no property damage, tons of priors, minimal injuries, and you're putting your hand up in the air to try that. And my question, because I think a lot of attorneys, people talk about, oh, there's not the opportunities to try cases like maybe there was in the past. And that is true.
It is.
But I also believe that, if you are dead set on finding a way into court, you can get there. And so my question to you is like, what do you think it is about you that you were willing to, to put your hand up and I want to try that case right off the bat, a couple months out. I don't know what the hell I'm doing, but I'm willing to try it out.
Well, talk about you don't know what the hell you're doing. I'll never forget picking that first jury. It was up in Erie County. I know you got your recent verdict up in Erie County. And the judge was Judge Dunleavy. I don't know if you ever tried a case in front of him.
I know, I've not tried, but I've been motions in front of Dunleavy.
Yeah, well, you probably saw the stars hanging in the corner of his courtroom since I can't remember if he was a 2 or 3-star general in the Army. So no nonsense kind of guy.
Yeah.
I didn't know what the hell I was doing. I certainly thought I did. But he let me know multiple times through the trial that I didn't know what the hell I was doing. But look, it made me a better trial attorney in the long run for it. So I don't know. I can't sit here and psychoanalyze myself and say what inside of me made me want to do it. But a lot of them, number one, is first, sometimes you don't have the choice, right? And then you just got to be willing to get in there and do it and figure it out, right? But after you do it a couple times or even that first time, in my first one, I got a verdict. I won, but it was like for 50 cents. I mean, it was literally nothing, but all it did was make me want to get back in there and do better the next time, right? And then if you suffer a couple losses, it's like, man, I'm just waiting to get a good case, good facts, so I can actually get a win and get a verdict. So
yeah, I can remember. I tried tons of dog cases, and I did not even get the 50-cent verdict for a long time. But I remember I got to a point where I was trying a case up in Mercer, and it was a med mal, and it was a very, very difficult case. And I got negligence, which was a shock, and I think we lost on comparative in a med mal case, which is unusual. But I remember that Judge Dobson afterwards telling me, you need to tell your bosses to start giving you the gravy, rather than I had some other terms, like instead of the turkeys or something. Because I think that was the second or third case I'd randomly tried in front of Dobson. And he was basically paying me a compliment, like you're improving,
right.
like you're doing well, and you're ready for better cases. And I think there's a lot to be said for that is, you kind of all the beatings and everything, I always think sort of prepared me for when I do get the just case, the righteous case, the people that really need to have their story told. Like now you're ready for it,
Right.
Which I think is all part of the process, and people kind of lose sight of because I think they get worried about losing or embarrassing themselves or something at trial, and it's like that's just comes with the territory.
It does, and I mean Mercer County. I do a ton of work up in Mercer County. As you know, we're north of the city, about an hour. I sit here and say the city. For us in Western Pennsylvania, that's Pittsburgh, New York City or Philly. So we're really out in the country out here, which we enjoy, and we do good work, and we get good results out here. But Mercer's a tough venue, so I know how you feel. I've done a handful of trials up in Mercer and taken my lumps. And similarly, I tried one up there. It was a trip fall case, And in hindsight, looking back, I can't believe I tried this thing. I mean, they had rugs from door to door, wall to wall. They had, wet floor signs. I had a clerk that was wiping the floor with a rag on video. But needless to say, the jury deliberated on a Friday night for like 6 hours, 7 hours. So you get your hopes up. You think you're going to win, and it came back as a defense verdict, unfortunately. But similar thing, the judge made a similar comment like that. It wasn't Dobson. It was one of the other ones up there, which was good, and it, encourages you to keep going and keep doing.
Right. Yeah.
Naturally, it was funny you bring up, my boss when, I told him about that. He didn't care too much what the judge had to say. He only cared what the jury had to say.
Yeah.
And look,
Right.
that's a tough lesson, but that's the truth. He was right. He was 100% right. And I think that for young lawyers, young trial lawyers, you got to remember that you got to give respect to the judge and understand, they're like the ref in the game, but your audience is that jury, right? And I try to tell some of the young lawyers in my office that you're presenting this case to 12 jurors. That's where your focus needs to be, not what the judge thinks about this piece of evidence, as long as you can get it in, right?
Yep.
But you got to think whether it's going to land with the jury or not.
Yeah, I mean, I was just I teach a trial strategy class at Pitt, and
Right.
yesterday's topic with the class was jury selection, and I do not claim to be a great selector of juries, but to the point you just made, I say like the starting point I think should be, looking at it from the point of view of the people that are in that veneer, looking at it from their perspective, like what do they need, what do they want, what are they thinking and experiencing as you're selecting that jury beyond just, what question, what answers are they going to give you? It's sort of like the more you can see things from their perspective, the most important people in the courtroom, arguably, I think the better you will be at, potentially picking a jury and certainly trying a case for your
Yeah.
client. So, you've teed up the fact that, your client, widow, she loses her husband due to a confluence of medical negligence from what I am reading. And she is somebody that needs to have her story told. And you, Patrick, were the fortunate one to get to tell, at least a portion of it, because, I think other portions I understand resolved, but, lay this case out to us sort of, when it first comes to you, what is it? And then how does it, change over time to the point of the case that you ultimately try and get this verdict on?
Yeah, that's a pretty long story actually, and I'll try to give the Cliff Notes version of it. But the case didn't become mine individually until the very end for this trial against the PCP. Prior to that, my partner Dallas had worked it up, and he did a great job working it up. He gave me all the ingredients to put it together and do a good trial against the PCP. But as you know, before it was a trial against the PCP, we also had an ortho involved and a hospital involved. So the framing of the case changed dramatically, right? So what had happened here with the case was the trial court let the PCP out on causation at summary judgment. So we didn't appeal it at that time. We ended up getting right up to trial against the ortho in the hospital. And you know how it goes. We end up resolving the case on Friday at 7 p.m. and trial starting on Monday. Okay. So then at that point, once that all wrapped up, we ended up appealing it, getting the summary judgment ruling by the trial court overturned. And this was a causation issue, which was a huge issue through the trial, one of the main defenses. And then it comes back down and it lands in my lap to take it to trial against the PCP. So as you know, you'd sit here and think, well, okay, you got 2 days out from trial previously, so you have a lot of stuff prepped. It was more of a hindrance than anything, right? Because the case was completely different the first time versus the second time. So kind of had to throw everything away and scrap everything and kind of start from square one on this. But so that's why it took a number of years to ultimately get to trial. So essentially what happened with the case is my client, Mr. Nygon, he ends up falling in 2019. He was taking his daughter, big volleyball player, out to a tournament in New Jersey. He falls down the steps and he ultimately tore his quadricep. But when he falls, doesn't know what he does. He goes to the local hospital. Ultimately, and he goes there and he says he's worried that he might have a DVT, okay, because he has a history of DVTs. So as you can imagine, defense counsel was all over that, his knowledge of his history, etc. Comparative fault. They do a Doppler, it's negative. He's told, you don't have a DVT. And what him and his wife were thinking, hey, why did I fall? Was it because of this? They don't have any medical training or medical background. But he's told, hey, you did injure your knee. You need to go see an ortho.
What,
Goes to see.
could I jump in real quick?
Sure.
Why did he have this history? Did he have
Well, we're going to get to that,
coagulopathy
right?
or something? Okay.
Right. So,
Okay.
so what happened? So what happens is, just to finish the part of the story in 2019,
Yeah.
He goes and sees the ortho. Ortho says, yep, you got a tear. We got to have surgery. Go to your PCP, get preoperative clearance, which he does 5 days later. Then he's in surgery 3 days after that. They repair his quadricep tendon. Surgery goes perfectly fine. The ortho tells his wife, everything you need is in the discharge papers when you're discharged. She says, great. He gets discharged. There's only a prescription for pain medication, oxy in there. There's no anticoagulant in there. Okay. So as you said, it was a confluence of everybody dropping the ball. But the reason why he needed the anticoagulant takes us back to 2017, treatment that he had with this PCP. He had an unprovoked DVT back in 2017, and it was actually a DVT and a PE. So he goes and sees the PCP because he has some shortness of breath, classic symptoms of having a PE. Ultimately, the PCP is trying to tell him, no, don't come here, go to the hospital. My guy wouldn't go to the hospital, went to the PCP instead. And this was part of, non-compliance defense as well on the comparative. At every turn of this treatment between 2017 and 2019 was a big theme for the defense. But he comes in, the PCP ultimately does the right testing, confirms that he has a DVT and a PE. This is back in 2017, puts him on Eliquis for 3 months and it resolves it. But what he also did was a coagulation panel to determine if he had any acquired or hereditary thrombophilia. Okay. So he does that, comes back, the testing comes back, and he tells a guy that it's negative. Everything's negative, right? So my guy moves forward in life thinking, hey, I'm good. This was a one-off. He's not on anticoagulant going forward, and not told he has any hereditary thrombophilia. So when he falls, a year and a half later in 2019, he says, hey, I had this once before. And he tells the hospital, he tells the ortho that he had this once before, right? And that goes to causation here for the case against the PCP. But what the PCP did back in 2017, he ordered an incomplete panel. So not all of the acquired and hereditary thrombophilia were on this panel. So he left out key ones. He left out prothrombin G mutation, which is the second leading cause. He left out antithrombin 3. He left out a few others. Okay.
Why did he do that?
Well, that was a big question going into trial. And when he finally got on the stand in trial, lo and behold, come to find out, because he's just too damn busy. He's too busy. And it ultimately became a theme in my close that he was putting his business interest, not just his primary care practice, but other businesses that he had, over the success of his patients.
Yeah.
Okay. So I'm sure we'll get there, but ultimately on cross-examination, he tried to blame the lab, etc. But ultimately I got him to admit on cross that it's his responsibility to order it. It's his responsibility to order the correct panel, not an incomplete panel, which, when you think about the language of the case, right, trying to keep it simple for the jury, it's like, hey, whenever you send out blood work in a panel, it needs to be a complete panel, not an incomplete panel, right? Just, you do your job, you do the complete job. You don't do an incomplete job. I don't care what your line of work is.
Yep.
So different things like that. So, through my partner, Dallas Jr., who worked this up, he's actually the one that, dove into this and found this, that it was an incomplete panel. So ultimately, the wife and the kids get tested, and the wife's negative and the kids are positive for the prothrombin G mutation. So you know what that means, right? He had the prothrombin G mutation. If a correct panel would have been tested for back in 2017, most likely he would have been on an anticoagulant given his age going forward for the rest of his life.
Now, that's really interesting though. So he was no one ever diagnosed him with his clotting disorder. It was put together posthumously by getting the kids tested and the wife tested, and then it had to be he had to have had it by the fact that the mom doesn't and the kids have it.
Correct.
Interesting. That's fascinating.
Yeah, so nobody disputed that in trial. Naturally, my PCP expert, said this is completely unacceptable. You need to do a whole panel, and in particular, you need to do these couple, the PMG, prothrombin G mutation, and the antithrombin. You got to do them. That's, no question about it, and they weren't done here.
Did the defendant concede that?
No, it was interesting. It was another defense that came up was, number one, that he didn't have to do this panel with the first unprovoked DVT, okay, which again contradicted what he said in his deposition. So there was a lot of impeachment and cross-examination on that. And what the defense, part of the defense they came up with was, and you tell me, I wonder if you've seen this before, because I've seen it in a couple medical malpractice cases now, is, hey, this was above the standard of care. He didn't have to do this. The standard of care in the literature supports, and he had some support there, is that he just has to put on the anticoagulant. He doesn't have to do this coagulation workup. So
yeah, I mean, I think if that is told persuasively, that can make your job more difficult
sure,
because, you know, I think you've read the same books and things I have. It's, you know, we want to show like the most minimum, that like the bare minimum that they
right,
didn't do. And those aspirational standards, that can be difficult sometimes. But it sounds like you carried the day, at least in part, because of the, you know, that theme of, you know, too focused on the success of his businesses, you
right.
know, and not on the success of his patients, you know, probably, you know, helps you beat that.
Certainly. I mean, that theme didn't come out until, you know, I guess I'll call it, because picking the jury was day one, so I'll call it day 4 of trial, right? Up to that point, it was kind of, hey, if you do a job, you do it right.
Yeah, right.
We all know that. We all been taught that all our lives.
And I think that's a great way to counter it too.
Yeah, he clearly didn't. It's undisputed that he didn't, you know, but they were pretty persuasive. He testified, then he had a PCP expert naturally come in from Philadelphia. And, you know, I start crossing him a little bit in my opening statement. Okay. Try to attack a little bit of their credibility early on. I know some people say don't do it. Some people say do it. But I didn't have a lot to work with against this guy. So I wanted to hit his credibility a little bit early on. But he was good. He was smooth. He was good. He was a challenge.
Yeah, it wasn't Haynes, was it?
No, it was Perkel.
Okay, gotcha. Yeah. So, but I just want to kind of put some of this in context because, you know, again, your case is particularly challenging for a variety of reasons because, you know, arguably the quote best claims settled, and after those settle. Okay. And the case is most likely, you know, typically, you know, you have your targets and then there's kind of the, you know, the second or third or fourth kind of, you know, down the list. And they don't oftentimes get worked up and focused maybe the way you would like, although sometimes that can weirdly work out to your benefit sometimes. Sure. It looks like you're not focused on someone because, you know, some good stuff can come up there. But anyway, you know, so now you settle those other cases, you take the appeal up. And by the way, I mean, what was the big causation hurdle here? Because I'm understanding PCP doesn't order all the, you know, coagulopathy tests. And had he would have identified your client's clotting disorder. And I mean, why is that not directly causative if he dies ultimately from a PE, from a DVT, you know, and nobody treated him, you know, properly?
And to add to that, this PCP did the preoperative clearance. Didn't put anything in the clearance about his clotting history. Didn't warn him, didn't educate him, et cetera, about the clotting history. Essentially, part of their argument was, that's not my job. That's the ortho's job. My job is to make sure he's healthy enough for surgery. Is his heart good? Is his ticker good? Can he undergo anesthesia? And there's a ton of literature that supports that aspect of it. But you still need to do a risk assessment. Okay. And again, that was one of the big fights in the case, saying he needed to, them saying he didn't need to. And it was the ortho. So to get to the causation point, you know, why it doesn't go to causation, essentially how they framed it and how the court initially agreed with it was that the PCP didn't have any privileges at the hospital. PCP wasn't their day of surgery. The PCP wasn't responsible for post-operative care. The PCP it wasn't his job to write the prescription after surgery. All of that laid with the orthopedic surgeon. And that's true. I mean, that was undisputed. So essentially, and a big part of their closing argument through the entire case was, hey, all this stuff that Attorney Sullivan's talking about doesn't matter. If the ortho would have given Mr. Nygon his script for anticoagulant for Xarelto, he'd still be here. Right? So
that is a problem.
Yes.
How did you overcome that?
Look, it was kind of coming into it, and that was the big thing. How are we going to overcome that so it's how do I frame the case?
Yeah, how do you
Okay.
frame the case when you've got obvious empty chair defense?
Right. Well, you got the empty chair defense. You have comparative fault because Tom clearly knows that he has this history. Okay. And then you have the causation, which was a big one. And then a few other defenses came up throughout trial. One of them was they were arguing that he would not have been on an anticoagulant from 2017 up through the surgery because you got to balance bleeding risk versus clotting risk. Okay, given his age, some other things that we can get into later, he wouldn't have been on it anyway, is what they were arguing. Okay. But nevertheless, so how do you frame that? Look, I figured the best thing to do was be as honest and credible with the jury as possible. Come in and tell them, hey, PCP's not the only one who fucked up here. Part of my language. Naturally, I didn't use that with the jury, but PCP's not the only one who messed up here. Ladies and gentlemen, I'm going to tell you this right now, day one in my opening statement. The ortho failed Mr. Nygon as well, too. Right? So framed it that way, wrap my arms around it. But again, as we know, language of the case, 2 wrongs don't make a right. Right? So just because party B failed this man, that does not absolve party A for his failures. Okay? And then we talk about all the failures for the PCP, right? And kind of in closing arguments, one of the things that we did, and I know you do things like this, I'm sure you do, and most other trial attorneys, I'm not creating anything special here, but, I'm part of my slideshow, because apportionment was a big part of this.
Yeah.
Okay. And the comparative fault was, let's look at what the PCP did, all the opportunities he had, right, to save Tom's life compared to the opportunities that the ortho had. And really the ortho just had the one visit before surgery and then the day of surgery, where the PCP, who is his medical home, right, had all these opportunities, failed him back in 2017 all the way up through 2019. So I told the jury in close, I know we're getting ahead of it, but make your own list, right? Don't take my list. Now, you're sure I put a list up there on a slide of, hey, PCP, boom, 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 as big as I could fill, all that. And then the ortho, there's 2 bullet points, but told them, don't accept my list, go back there, discuss, make your own list. So, those are a couple of different ways we handled it.
I'm trying to remember the psychological term for it. I was trying to search. I read this cool article. It's like you always read, you learn these different things in the trial books or trial blogs, articles, and stuff, and you can't use all of them in every case.
No,
it's like
it'd just be a mess.
Yeah, but as you start to collect things, they like sort of sit in your brain, and then you're like, oh, I can use that thing in this particular fact pattern. And I was reading this article, and they were talking about basically exactly what you did, comparing the PCP to the ortho, which is there was one inflection point where things could have gone different. Okay. But with the PCP, there was this one, and then there was this one, and there was, this, and there was all these different little points, any of which would have drastically changed the future. And whatever the article I read said, that's a super compelling argument if you have the right facts. And but that's a perfect example of it right there to kind of make that point, especially comparatively between the two.
Well, and then take it another step, right? We had the comparative fault of my client as well.
Yeah,
which was a big concern.
Yeah.
Because he knew his history, and literally every doctor he went to, he said, hey, I got this history. And there was some information in the PCP's medical records that he did his own research, diagnosing himself, Google, all that.
Yeah.
So that was a big thing. But, we kind of had to put that into context in that every doctor he saw along the way, no one told him he needed this after surgery. In fact, it was completely silent. Records are silent. They're silent. Now, naturally, compare their testimony to the records, all that good stuff, etc. But going back to, he's literally told he doesn't have a thrombophilia, right? A genetic or an acquired thrombophilia. And then when he falls, he gets a Doppler and he's told he doesn't have a clot.
Yeah.
So what's in his mind as a non-medical person, right? So trying to put it into context with it. But like you're saying, all those inflection points, it worked that way too. Right? A normal individual compared to the doctors.
Yeah, to counterbalance the comparative as well.
It did. And that was a big thing is, we did, it was funny, because you talk about like predict, focus groups, etc. Now, we did them but we did them when everybody was in the
Yeah.
case.
And then it's like,
Okay.
well, what can you take from that? When you now just
Yeah,
have this case. I know. I've
you
been down
got
that
it. So I
road.
pulled it up. I pulled up, the stuff I had, and I'm like, yeah, this isn't helpful at all. But two of the things that jump out were comparative fault of Tom, and not just him, but his wife. So there was a lot of negative attribution in regards to spouses. Like, hey, I'd never let my husband walk out of that surgery without, a prescription for blood thinner.
Sure.
There was a lot of that. So we had motion eliminate fighting on that. And quite frankly, the best way that was handled, she was amazing. It was some of the best testimony I've ever been part of.
That's what Matt had said, that she was an amazing client, amazing
She did
testimony. It sounded
such a
like the
good
daughter
job.
was great too.
Yeah, yeah, such a good job. Well, so much so in my close, and again, it's about to get a verdict, not just about the facts, but they got to feel the jury has to get emotionally vested, right, in it. You know that. So part of, one of the little lines in my close was something about because the PCP essentially called my client a liar, okay, in so many words. So I addressed that in my close. And after I addressed it, credibility wise between the two, I kind of pause, turn to her and look at her. And I say, hey, ladies and gentlemen, talk about insult to injury, him coming in here and saying some shit like that.
Yeah, absolutely. That's great.
Yeah.
Well, tell us a little bit about, the family, the client that passed, wife, daughter, because that was one of the things I remember in talking with Matt was like, this family was just great, great
Yeah.
family, great family to represent.
Yeah. They were really good people. The father who passed away was originally from Pittsburgh, met his wife where she was working down in Pittsburgh, and then she dragged him back up to Lawrence County in Newcastle. So we had some jokes about that, in front of the jury. I think everybody appreciated that. And then they had two kids, just, classic American family. They had a son and a daughter. Daughter was weeks away from graduating high school when this happened. So it just destroyed her senior year. And then the son, Max, he was in his second year at Penn State, up at Penn State Barron. So, classic family. Daughter was a big volleyball player, ended up playing volleyball in college. Dad was highly invested in the kids and all their activities and whatnot, type of guy that would drive down to Pittsburgh. He worked at a bank, bounce around his branches and whatnot. And then he'd drive up, pick her up, turn around and drive her right back down to Pittsburgh for the travel volleyball team. I mean, this guy was an absolutely just dedicated husband, dedicated father, and that's the story in the picture and how we painted it.
That's great. And I mean, as you think back on it, what did you think? I mean, was it just their overall vibe of high quality, or were there some particularly, poignant anecdotes you can recall from their testimony that connected with the jury?
Yeah, 100%. So what I try to do, and again, I don't know where I picked this up and reading one of these books, is, when I wanted the mother, the daughter, and the son to talk about each other's relationship
100%. Yeah,
not their own.
exactly.
So Max, his whole direct was about Abby, his sister's relationship with her dad, right? And how he was a girl dad through and through, and how that relationship really blossomed as she got into sports because he played college football, right? So we had some stories and anecdotes about that, about how he was never missed a game, never missed a tournament, was that was at every single one. And then we tied that to, what he missed. So Abby then testifying about seeing her mom sitting in the stands at college by herself without her dad.
Mm-hmm.
Right.
Yeah.
So I think that hit pretty well. And then this guy was such a good guy that his daughter was a lifeguard at a local pool, at, the local township pool, where he would go when she worked and he would swim like in the old man swim league, or even when it wasn't, just to be around his daughter and hang out with his daughter. So the supervisors of the pool actually sent her a picture of him teaching some little kid that he didn't know at all how to swim. And I thought it was a little kid when she told me, and she sends us over. Kid's got to be a teenager, like 13, right?
Yeah.
And so clearly they're not related, don't look alike, and it's this picture. And they put a quote on it from Mr. Rogers. And it was the quote, and I'm sure you're familiar with it. A lot of people say, not my kid, not my community, not my problem, don't care. Then other men step up, take action, So that was one of the things that I put up during her examination. And I had her read that quote, and it was really funny because then I say, how was it signed? It was signed Fred Rogers, underneath it. And I just had a feeling. I could just tell that Abby didn't know who Fred Rogers was. So I made a comment about Mr. Rogers, and she was like, "Who's that? Who's Mr. Rogers?"
Yeah.
So naturally, all the jurors are our age or older. I
Yeah.
think I had one or two younger ones. So I kind of stop and I'm like, "You're telling me you don't know who Mr. Rogers is?" And
Yeah.
just kind of shake my head. We laughed. The jury was laughing and whatnot. So we had a number of little stories like that. Like mom told a story about, uh, which I thought was very touching when they moved Max into college, which was just about a year before this,
Yeah.
how Tom had a bag packed. She's like, "Why do you have a backpack? Like, we're moving him in and driving home." Tom's like, "Well, I thought he might want to go to the gym with me, his first day up on campus." Leslie was like, "He's not going to want to go to the gym with you. So
Yeah. Yeah.
little things like that, I think, really affected the jury. And then Max talked about the relationship with their mom and how after Tom died, I mean, she's an empty nester within a couple months because Abby goes off to college. He's
Yeah.
back at college, and how she would call Max all the time, lonely, scared, by herself. So we were able to capture a lot of that good testimony with the with the family members.
So so you talked earlier that, it sounded like you guys had done a predict, but you'd done it earlier with everybody involved
Yeah.
and maybe some other focus groups. When it's now, you win the appeal, you're coming back, you're going to try the case against the PCP with empty chairs and so forth. Did you do any more small focus group yourself, or did you just try to take, what you knew were going to be the significant problems from what you learned before and then kind of repurpose, address it to get ready for this case?
Yeah, that's a good question. It was majority taking what I had, repurposing it. Like I said, the prior focus groups and the predict were pretty much useless at that point because it was a totally different case at that point.
Mm-hmm.
But I always try to, and I'm sure you do too, and a lot of other attorneys. I talk to people about my cases all the time.
100%. Yeah.
Right. It's probably a problem, and people probably find it very annoying.
I have nothing else to talk about.
Right, exactly. But you know how it goes. It's, "Hey, what do you think about this?
Yeah.
Hey, what do you think about that?"
Yeah.
So I mean, that was about it. But you're constantly batting it around, whether it's in the office or with my wife, et cetera. Get some of my best ideas from her.
Yeah, me too.
Yep.
Not your wife, my wife, but
Right. We're not going to cross that line, Brendan. I'll have to drive down to Pittsburgh, and we don't want that.
So mechanically, do you in opening, do you follow a typical format, or does it depend on the case that you're trying? And how did you present this case, like sort of structurally to open to this jury?
With the open, I think the ball method is great. That's a great method. That's one way to skin the cat. It's kind of like we talked about before. It's multiple different ways to skin the cat.
Yeah.
If you listen to like Raleigh, he does it very different
Totally.
than Ball does.
And seems to mix it up a lot too, which I'm like, this is crazy. But
which is good though. But it depends on your audience, depends on the case, the facts, etc. So in this particular one, I felt it was I thought the framing what the rules were for the PCP.
Yeah.
And, I had to have at least two. And that's what I did. One for the 2017, then one for the 2019. And that was a big part of the trouble, framing it to confine it down just to two. And then telling the story, as we're taught from all our books, in a very non-argumentative, flat way. Just, hey, here are the facts. Boom, boom, boom. And I framed it going all the way back to 2017. Okay.
Yep.
Up through the time he died. And then typically I told the jury, well, I didn't tell the jury. I thought about this, how I wanted to do it. After he dies and he had this massive saddle pulmonary embolism that blocked the flow of blood to both of his lungs, typically the story stops there. But in this case, and I don't know if Diago told you about this, the story didn't stop there because the next day, and so I went back and forth. Do I want to give this segue into this? Right?
Yeah.
Because you could word it nicely as we are here, or just do it factually. So I just did it factually. Right. So May 14th, he dies. This is what he dies from. I pause, give it a few minutes. On May 15th, the PCP goes into his medical records for this guy, starts adding information that wasn't there before he died. So he went into the preoperative clearance note, added information, and then he went into the 2017 note when he did the coagulation panel and added information into there. So naturally, it goes try to lie. So that became a part of the case. I had a electronic medical records expert testify. It was her very first time testifying in court.
Yeah.
You've never seen anybody more nervous in your entire life, and it showed. but it played. It played, compared to all the hired guns that were coming in through this
Yeah.
trial.
Right.
So, they had a pretty good response to that, saying, hey, he was just closing out his medical file, right? He knew his notes were incomplete, and they did say incomplete and then complete, but he needed to close them out. I don't think the jury bought it, clearly based on the verdict.
Yeah, it's like, well, why wasn't that information there to begin with then?
Right.
And
Well, look, because he's so busy.
Right.
He was so
Exactly.
busy.
Right. Kind of feeds right into that theme too.
Yes, it did.
So is that where the story ends, or did you incorporate into, I guess there wasn't a lot of fight over it, but did you incorporate, because I think it's just so fascinating what you guys did to have the testing to confirm that he had this clotting issue from testing on the family?
Yeah, and I did touch on that in my open, right? Because, the part where you talk about how do we know this guy violated these rules, how do we know he did wrong, etc. And that was it. And again, I got to give all credit to my partner on that one who handled this case, Dallas Jr., the workup of it and seeing that.
Yeah, it's great.
Checking into all that, because that was huge. But I touched on that, naturally, to establish what he did, was wrong in 2017. And here's how we know, right? All that, and then what they're going to hear from, and then addressing some of the defenses. And it was one of those things where we knew, what, a handful of the defenses were, but, some came up as trial went on that I didn't address. So
who was your first witness?
My PCP expert. And I actually, very good question, because it was going to be the defendant doctor.
Yeah.
And I know there's a lot of people that are like, hey, start there. And I have before.
Yeah, it goes back. I mean,
It does. It does. And I didn't want to start with my family and my client. I wanted to save that till a little later.
Yeah.
Because this was such a highly contested liability case with all the defenses. Said, hey, I gotta win on this front end before we start talking about how this affected this family. Mm-hmm. So the deposition wasn't quite as tight as I would want it to be for the PCP, and I didn't do that deposition. I had a lot of gold in there, which worked out well, as you kind of hit on it when the case was really focused on other people. Some of the things maybe weren't caught that we were able to use in the trial.
Yeah.
But I just knew that it wasn't going to go as smoothly as I wanted to call him first, because the first way I laid out my witnesses, he was going to be first. So I changed that, week or two before trial, and I called my PCP expert first, which, I'm a big believer in alignment, right?
Yeah.
And, some of these guys talk about it. Like, I think, hey, if I tell this story, in the beginning, because it's all about our credibility, it needs to align.
Yeah.
Those first couple witnesses.
Order of proof kind of following in the same order.
Right.
Focus on the defense liability, transition through causation, and so forth. That was the way that you did it,
Yeah. Well, that, yes, and aligning with supporting what I said in open.
Yeah.
Those first couple witnesses have to confirm my story, right?
Number
my
one in
version
particular,
of the case.
but yeah.
Yes.
But yeah.
Yes.
And that's why I was curious about your first one. And so were you happy with, because it's, Greg and I tried a trial in March, and we had a great expert, and I felt really good with Greg's direct of our expert. But then on cross, he got kind of riled up, and I wasn't feeling as good about it afterwards. How are you feeling overall after the PCP expert, both direct and cross?
Very good.
Okay.
Very good. He handled himself very, very well. And I believe it was he does, litigation work, medical legal work, but I'm trying to think. He's only testified. I can't remember if it was maybe 3 times in trial. I believe this was his 3rd time testifying in trial.
Yeah.
But he was a cool operator. He handled, he followed me on direct, knew where I was going, did a great job, and then on cross, he stood up to it. And what kills me, and it probably kills you too, is when your experts, you love it when the other expert does it, the defense, but when your experts just don't answer the question on cross.
Totally. Yeah.
And they're just trying to be evasive. He was not that at all.
That's
great.
Was
wonderful.
Yeah.
Yeah. He answered them very matter-of-factly. No, I don't agree with that. Here's why. One sentence.
And that's what you want. You don't want to just answer the question. Whatever your answer is, better than like hemming and hawing and clearly trying to avoid the answering.
Right. I had another expert who was my hospital administration expert, because I told you we framed the case, but showing the jury everything, how this healthcare system works, the PCP's role, ortho's role, etc. Okay. Again, 2 wrongs don't make a right. And that was a judgment call. Do I bring him or not? Because this guy, naturally, when he originally wrote his report, and there were a couple of reports, he puts liability on everybody.
Yeah.
All the actors. doctors. So that was, a risk determining whether we were going to call him or not. But ultimately, I felt it was necessary. So he did a very good job, very, very good job. But then on cross, he did kind of what we were just talking about, where he, gave very evasive, very long-winded. And I talked to him afterwards about it. Like,
yeah.
You can't do that.
Yeah.
Can't do that, But,
and that was the hospital admin expert.
Correct.
You call him
Correct.
right after your PCP? Those were your 1 and 2?
Nope. I did PCP expert. Then I did my electronic medical records expert.
Okay.
Right. And I kind of just set the table with each witness to get to the next witness.
Okay.
Because I think you've probably seen it. I've seen it when witnesses are redundant. Juries hate it.
Yeah.
Absolutely hate it. Right.
Yeah, wasting
so move
their
the
time.
story along.
Sure.
Right. So I did her, and then I switched from expert witnesses to lay witnesses. So I like to kind of mix it up back and forth for the jury, from expert to lay, if I can.
Yeah.
And it just depends on the case. And in this case, I was able to do that pretty well.
Was that the family members were the lay witnesses?
I had 3 other witnesses that were non-family members. And one of them was my client's secretary, who actually talked to him the day he died. She was on the phone with him. He was working from home, laid up with his leg in the brace, was doing work with her on the phone when he starts having the pulmonary embolism. So she set the table for those damages and what occurred that day.
Yeah.
So she was my next witness after that. I think we ended there that day. And then the next morning I started with the wife, because she got off the phone with Tom and called the wife, who worked at the local school a mile or two, and ran home and unfortunately witnessed everything that occurred.
Oh, wow. Yeah.
Yeah.
So did you end up calling the defendant in your case in chief?
I did not.
Did you play any clips of anything that he had said in depo, or read any of his testimony?
No.
Okay.
No, instead of reading it or playing it, I, number one, saved that for cross-examination over in their case. And a lot of it was played when we got to that point. I would say a lot, but some of it was. I'd frame the questions like this. And again, 3 different ways to skin a cat, right? Play that depo clip, or, because there were a lot of witnesses in this case. I mean, I think they came in around 13, 14, something like that, witnesses total for the jury, and it spilled into the second week, unfortunately. I tried to avoid that at all costs. But that was defense counsel, when they moved their case, and I know I'm getting on a tangent here, they spread their witnesses out, right? Like day by day. There was no reason this should have went into the second week, and the jury was pissed on Friday.
Yeah. Right.
Oh yeah, I had a couple people watching the jury, in there from my office, and they were like, Patrick, this is a problem, So again, good I had that, because got to address this in closing argument.
Yeah, totally.
So very subtly, I let them know that the reason we're here today is because of defense counsel. But, going back to your question, I would ask my witnesses, my experts, you read Dr. Malvar's deposition. He testified to XYZ. Do you agree with that? Why not? Whether it was something like that, or anticipating, what the defense experts are going to say. If somebody comes in here and testifies that this is all the orthopedic surgeon's responsibility and the PCP has no responsibility here, what say you? Whatever, questions like that.
Well, and I think because it's like every med mal seminar, they always have the, who thinks you should call the defendant in your case in chief and not, and you get the 2 camps. But I mean, I just don't know how that, the answer is it depends. It just depends on the type of case. It depends on the fact. It depends on how the testimony came out. It can never just be, it's always this, it's always that.
No,
and your case
it can't
proves
be.
that.
Can't be. And I agree completely. And with this one, it came down to, like you say, it depends what your other witnesses are. And this PCP was one of the most likable human beings in the world. Extremely, extremely likable. So that was another huge hurdle and concern. So putting him up first and putting his good face on there. And they had, all the defenses that I was dealing with in this case, plus some we haven't talked about. I didn't think it was a good call, and it's dependent case by case. And I told you, some areas in the deposition weren't quite where I wanted them. And that happens with all of us when we take depos, So I felt the best course of action was to cross-examine him. And it actually worked out extremely well, because I finished my case, we'll say trial time wise, in a little over 2 days.
Yeah.
Okay. Try to put in a quick, efficient case. They called the defendant doctor PCP as their first witness. And he did not come off well
Mm.
at all. At all. He came off, it was shocking. It was shocking because, you know, you always got to think about your presentation when you're crossing people. Can't be a bully to a little old lady,
Sure.
you know. And told you in those dog shit cases that I lost, I learned that lesson the hard way.
Me
Right?
too.
No little old ladies, but, you know. So I thought I was going to have to be very reserved, very kind to this guy, or bring him along. But I just think after 3 days from picking the jury to when so we started on Monday and Thursday when he gets on the stand to testify, I don't know, but I think sitting there listening to all that testimony that A, he was incompetent, and B, he wasn't credible, right? And when it came to these medical records, you still there? We freeze here.
No, we're there. I don't know if you hit a button or something. There you
It
are.
might have been. Yeah, it might have been me most likely.
Yeah, no
but
sweat.
as I was saying with this PCP, I think just sitting there getting beat up for those, 3 days before he got on the stand as to A, his credibility, and B, whether he was a competent medical doctor. He got up on the stand and was aggressive. He was aggressive, like leaning into the microphone and almost yelling. So naturally, I sat back and thought, oh, okay, we're going to change our tact here. This is going to be fun.
Yeah.
Right?
That's, I mean, and it probably it had that benefit that he's seeing all this compelling testimony from the family, and he's just having to sit there. And it probably, had you called him first, he probably would have come off a lot different than he did by that time. Now he's feeling agitated, maybe worried and concerned, and feels like he's got to somehow, save the day for himself, and it comes off poorly.
Yeah, very much. So much so that we ended that day. So that would have been Thursday. That was the end of the testimony for the day. And the judge brought us into chambers, and had a little talk and, in a very judicial manner, let defense counsel know that it didn't go too well for his client.
Yeah.
But we talking, there been any discussion between the two of you,
Like hint.
Yes.
So were you feeling pretty good about the trial throughout? I mean, were there any moments where you're just like not feeling so hot about it or getting concerned, or were you feeling mostly like it was going well?
My case in chief went in very cleanly, so I felt very good. But as I told everybody back at the office, let's not get ahead of ourselves.
Yep.
We still have a whole second half of the case to go. And I know they had very good experts coming in, and I thought that he was going to come across the defendant doctor, very well, but he didn't. Fortunately for us, and I think that definitely helped.
Especially being their first witness, it's him coming off poorly is huge for you.
And then again, they just bring in some hired guns to support his testimony, which, as I told you, I kind of started crossing a little bit in my opening statement, very subtly. Hey, these guys are coming in from Philadelphia. You're going to know who they are when they get here, etc. That type of stuff.
Yeah.
But no, I would say I felt pretty good all week. Their PCP expert did a very good job. He was a tough one. He was tough. So I felt good about I felt very good about my cross-examination of the defendant doctor. Very good about that. Did a lot of different things there, that we've learned, and they all went well. And then, I started his cross-examination with multiple impeachments. And getting to your point, that's when I played the videos.
Yeah.
Right? Because he said, hey, I didn't say this. And I'm like, okay, let's do this efficiently. As he put it up there, went through, the rigmarole. And then he was still trying to run away from it.
What he previously testified to.
What he previously, and this came down to about altering the records.
Yeah, right.
And so that was a good portion of the start of my cross-examination, hammering him very hard on that.
Yeah.
Okay. And then, so the only time was their PCP expert. He did a very good job. They called him the ortho also to put in a prima facie case against our ortho.
Mm-hmm.
And by that time, the trial had run so long, my cross-examination to him was like 5 questions.
Oh, yeah, right.
You got to know your audience. I said, I got to get in, get out. I could spend a week with this guy, but the jury's pissed off. They want this case over. So I think I might have asked him 5 total questions. And one of them was certainly to let the jury know that it's the defense's fault that the case is extended to this point in time.
Yeah,
right.
Yeah, absolutely.
It was one of those questions. It was something like, hey, are you aware that we all agree that the ortho in this case messed up?
Yeah.
No, I didn't know that. I said, so you drove all the way out here from Philadelphia to tell us something that's stipulated to in this case?
That's awesome.
Right. So there were a couple questions like that.
That's freaking great. I don't know if you've listened to that Joe Fried's
Oh yeah.
CLE on keeping trials short, and he had that same thing. So like you just said all this different stuff, and that's not what the issue is. Like the issue is this. So none of that stuff matters, and then you sit down and you're done.
Right.
That's great.
Joe Freed's excellent, and I like his talks and all of his lectures on speed trial.
Yeah, light switch issues, finding the issue,
Right.
simplifying.
But you got to balance that, because sometimes it doesn't work, and you compare that with some of the stuff Rowley talks about.
Yeah,
is really getting the jurors in that present tense of what's going on. Sometimes you can't do that too quickly.
Yeah, and that's
right?
why it's a mix, and you're
Right.
blending whatever the case needs, which you clearly did here. So feeling good throughout. I mean, the only maybe semi blip is the pretty solid defense expert, but it sounds like you're still out in front of that point. So how did you approach closing? And I have to ask you, because you made an argument that's my favorite argument, and Diadigo said yours was awesome. So I want to hear about your evil man or the man with the suitcase argument. But overall, tell me what you hit. How did you approach closing? And what did you think worked well for you?
Well, closing, and it's funny because we talk about all these different methods and strategies you can use. I got to control myself, right? Because I get fired up, want to get aggressive, etc. And I think that's hardest to do on cross-examination, to pull it back a bit. Fortunately, I didn't have to with the PCP, until eventually he laid down, and then you change your tone, and he's just agreeing with me.
Yeah.
But in close, it's always one of those things. Do you want to be the one that's angry and emotional about what happened, right, and lead them along, or not, and allow them to get angry and emotional about it? And I think that's a very hard balance to do. And in this one, I try to take that approach. I want them, right, to have the emotion over this, not me.
Yep.
But so the approach was going through the themes, and the themes kind of changed, like we talked about, because he talked about, the defense doctor, about how busy he was, about how all his businesses, and he rounds at the hospital, rounds at the nursing homes, all his patients. He has this cryotherapy business on the side, which actually became a good fact for us, because he had, I don't know if Diadigo told you this, after the preoperative clearance, he had our guy walk him down the hall into a cryotherapy chamber. Right. What's one of the first contraindications for doing cryotherapy? History of blood clots.
Yeah.
Any vascular issues. It's all over the paperwork.
Wow.
So, that goes to the incompetence and the selfishness of his business.
Yeah, like China now, like he's a multi-customer of the different businesses.
You got it.
Yeah.
You got it. I mean, it's a vasoconstrictor, right? And the jury had a visible reaction when I cross-examined the defense doctor on that. They were all like, what? Once I explained what it was through questioning him.
Yep.
But so in close, kind of did those themes, accountability, selfishness, business, business over patient success, running through all that, and then hitting, hey, how do we know he did that? Hit on, again, trying to work in a little bit of these themes about rushed medicine, doctors not taking time with you. And that's what that was part of what happened here every turn. And Leslie, the wife, did a very good job testifying about that. And she came across so credible, So hit that. Hit the whole thing is all these books tell us about addressing the defenses, responses to them, whether you're sitting in a chair like Raleigh says he does, not really my style, but I do like the, hey, if someone says this, you tell them this.
Yeah.
Did all that with a lot of these defenses, but the other way was through story, through story. So one of the things that came up in trial was my guy drinking, which just, I don't want to say it blindsided me, but they essentially took out of context that in one of the, notes, as we all see them, 2 beers per day.
Sure.
Right. Just 2 beers / day. So they tried to argue that he was drinking 14 beers a week, this extremely successful, good father, high earner, etc., that he was drinking 14 beers a week. Therefore, he was a bleeding risk. So that's one of the reasons you wouldn't give him an anticoagulant from 2017 to 2019. Okay. So that was a big part of the defense. So told a little story. I have a personal story on that. And because it was one of those things where I didn't, like, he said it once, and then it was like, okay, but defense came back to it like 3 times through the trial.
Yeah.
They came with their expert. They came with my wife. They came with Dr. Malvar, the PCP. And I'm like, you got to be kidding me. So it's one of those things. Hey, am I going to address this right now? Get up and ask Leslie, was your husband an alcoholic, etc.? Did he drink 2 beers a day? Didn't do it. Didn't do it. Save it for close, right? Can't fight every fight, which is
Sure.
one of those things. Get in trial on those dog shit cases, right? Because those were mistakes I made when I was young. And
Yep.
all you're doing is you end up just trying the defendant's case, right?
100%. Yep.
So I saved it for close and told a little story. And, I knew my jurors, and my jurors were very rural, very conservative. And a couple of them were VOTEC people. And I got a good friend who's a VOTEC teacher up in Erie. And his wife died in front of him, similar to how Tom died in front of Leslie. So I told a story about that, and it tied into damages, number one. But then I made the comment about how, number one, we need more good men like that. Mr. Nygon, and this guy's name's Katulik, one of my best friends, Mr. Katulik, not less. And I just said, hey, every time I go up to Erie, I said, me and Mr. Katulik meet after work and we have a couple beers. I go, let's not hold that against Tom and Mr. Katulik. They were like 4 jurors just nodding their head like you are right now, So
yeah.
So different things like that. And then, yes, as Diago said, when I got to damages, did I think you call it evil man, I call it the man in black. And that worked out nicely, I think, because
How did you do yours? Tell us how you set it up.
I set it up at the preoperative clearance visit.
Okay.
Because the testimony was that Tom went right from work and Leslie came home, after school, and then because she worked at the local school, and then she was meeting Tom over there. So as she steps out of the front door, there's a man in black with 3, and it was 3 duffel bags, not 2. Because he had Leslie, Max, and Abby. These are 3 separate wrongful death cases, not one. So when when I got to that point after doing the man in black story, you got to address each of these relationships and assess them and put a value on them each individually.
Yeah.
Right. To come to your verdict. So that's how I set it up. That's how I framed it.
And then how do you, do you do, we had this money for you and, but here's essentially what's going to happen, by you getting this money, and you tell them about they lose their dad and their husband and so forth. And then
right.
Do you then say, like, they pose them the question, like, like, okay.
Yep. Just like Riley says, so I did something like that, throughout the stages of telling it, and the whole, hey, after this nightmare, right? Going through this nightmare, but it's okay because I got these bags of money for you.
Yeah.
Will you take it?
Hell no.
Post it like that. And naturally, she says no. And, the man in black sits there and says, you're not getting this. This is done.
Yeah.
This happened.
You don't have a chance. And I think,
right.
To your point at the beginning of, we read and we learn all these, different, techniques and arguments and stuff from, other amazing trial lawyers, but then you kind of have to make it your own and internalize it. And I think for me, why I like that argument so much is that, at the end of the day, what it really is about choice and autonomy, and it's that I think it helps the jury understand money for the loss of what happened.
Right.
You know what I mean? Because it's like, well, if you're not given the choice, and we all know how important choice is to us in United States and as in humanity, that if you're deprived of that choice, well, then it makes sense that the second best thing would be, the money under the circumstances.
Right.
And I think something about that I think is really powerful.
It is. I agree with you. And I think, 2 things that you do when you do that, that I try to emphasize is that when you talk about choice is letting the jury know that, they didn't have a choice. This was thrust into their life.
Unnaturally.
Right?
Yeah.
You got it. This was thrust into their life, A, on the front side, and then B, on the back side, what's the fair market value?
Yep.
Right. And so, but I do believe, and unfortunately here in the Commonwealth of Pennsylvania, we don't get to do voir dire like they do in other states.
Sure.
Right. And have those open conversations, but you've got to talk about the money. I'm a firm believer in that. And again, that was something I've learned over time in reading and doing multiple trials. I talk about it in when I'm picking the jury.
Yeah. Yeah.
Do you talk about it when you pick the jury?
Well, it really depends. Every judge, it seems, let alone county, has a different way of conducting jury selection. And I will tell you, Erie, is the way we read about in the books. It's
Yeah.
60 people in a room, no judge, talk as long as you want to all of them. Hey,
Now,
Mrs. Jones said
yep,
this, Mr. Smith, what do you think about what Mr. Jones said? Hey, Bill
that's
back there, I
great.
saw you. So I think in there, like in the trial I tried recently, I did talk about money. What
Yeah.
this case is about, a very large amount of money that's being claimed for lost income related to a slip and fall. We're talking millions of dollars, ladies and gentlemen. What do people think about that? Does
Right.
anybody
What
have
do
a
you think
problem with
about
that?
lawsuits for slip and falls? What do you think
Yeah.
about lawsuits for millions of dollars? Sure. Now, think about you doing that now with all the experience you have, and me being 3 months with my law license, and the judge Dunleavy walking out of the courtroom and saying, "Hey, good luck, pick your jury." I'm sitting there with defense counsel, like, "What am I supposed to do right now?"
Yeah. Meanwhile, for that case, like, how do you feel about awarding $150, but
I will never forget the look of some of those prospective jurors, the looks on their face when I was picking the jury going through that process. So, yeah, it was that bad.
Just
But
to tie up the the man in the black suit, as you put it, the last, I think for me, because I do think it's a really, really effective, and it's fun to
mhm,
give. It's fun,
yeah,
you know what I mean? From
to get creative with it.
Yeah, and like the performative component, as long as you don't, and Greg, my partner, can confirm that there have been times I've gotten way too carried away with it. So I dial it back. I think that's the better way to do it now.
Right,
But I
right.
think a really kind of powerful ending to it is because it has to do with choice. And you point out that, your clients never had a choice, but then you can pivot to the jury and say, but you do have a
You
choice,
got it.
and
You
now
got it.
you're kind of passing the baton, the ability to do stuff and, agency to make a difference and a change to them. So I think for a lot of different reasons, it works so well. My ears
It
perked up
does.
when Diadigo told me you did a great one. So
I try to, and we won't bore the listeners, but we can talk more about it if you want another time. But I also, when you say the choice, that the jury has the choice. They have the power, right? Get to do something that many people go through their entire lives and never get to do.
Yep.
I always try to make that part of my closing, whether it's on the front end of it, and I believe here in this one I did it on the front end,
Mm-hmm.
okay, or on the back end. But going back to our conversation about, fortunately up in Erie County, how you get to do that open voir dire. Mercer County you can't, Lawrence County you can't, Allegheny, Butler you can't. I just
Tip.
picked a jury in Butler County a couple months ago. Case ended up, get settling for, get second day trial, but nevertheless, you don't get to. But I make sure that the judge asks those questions, and I'll fight for those questions.
Yeah.
You just have to, and then ask individual follow up if I can on it as much as
Mm-hmm.
possible. But then in my open, I have kind of put together over the years a little something that I talk about in my open, before I sit down, after I kind of go through everything about the American civil justice system,
You do it in
right?
an opening. Can you
Oh yeah,
can you share with me
yeah.
like how
Well,
you
it's
say it?
it's and I'm not going to remember it verbatim, right? But it talks about, and essentially, I think Mitnick does something like this, something in there, essentially about, like, how this lawsuit's about money. We talked about it in voir dire. You need to understand that and do the ball stuff about, because of that, I got to show you this, I got to show
Mm-hmm.
you that. But I'm trying to think of how I worded it. Something like, hey, the Nigons would love to have Tom back, right? And if you guys could do that, this is what the case would be about.
Yeah.
But you can't. Just like anybody that gets hurt in a car crash case, they want their health back, but you can't do that. So the next best thing is, and it's not perfect, ladies and gentlemen, it's not perfect at all, but the American civil justice system is giving compensation for what was taken from the family. That's it. It's not putting them ahead. It's not getting them in advance, not lottery, etc. It is valuing what was taken from them, and that's your job, right? And appraising that, etc., something like that. And I'll tie in that, we don't do, get biblical, eye for eye justice. That's barbaric, ladies and gentlemen. We don't do that in this country. That's how I started. That was the segue, right? And I
But
said,
we
what we do in
don't
this
turn a
country,
blind eye to justice
you
either.
got it. What we
Love
do
it.
in this country, the American civil justice system, right? So you got to make them comfortable and okay with it, that,
Yeah.
hey, and at least say, it's like, hey, you're allowed to do this. Because, a lot of people don't like it.
Since you are obviously such a student and latch onto the same just great phraseologies and arguments that I
Right.
do, I'm like damn, how the hell do they come up with some of them are so good, you know what I mean?
So
And I'm
good.
like, will
Well,
I
like you
ever
said,
one day come up with something like of my own that's like my own creative thing,
yeah, I
you
love
know?
because the comparison, and we don't turn a blind
Oh,
eye, but we're not barbaric
it's
either. I
so
mean, that's
money.
great. So,
It's so
right here's the
money.
middle,
Yeah,
giving money for what was taken,
yeah, yeah,
and again,
yeah,
the phraseology of what was taken,
yeah,
right? And God, who is it? Mike Leisureman, who's
yep.
big on it, right? I'm familiar with Mike
Oh
Leisureman,
yeah,
right? Words evoke emotions. When you say, "Hey, I lost my cell phone," versus "someone took my cell phone," totally different response that the audience has,
yep,
right?
yep.
They lost Tom. I say that once during trial. Tom was taken from them every time it came up.
Way different. Yeah, that's
Way
great.
different, right?
And speaking of taking, I've taken up a crap ton of your time already, but I want to wrap by,
Sure.
so was it a long deliberation? And then tell me how the verdict broke out.
It was maybe 2 hours,
Yeah,
and I think it might have been shorter, but it was over lunch.
yeah,
They got, how it goes. They get lunch, and I'm like, man, if it comes back in 1 hour, that means it's a defense verdict,
yep, yeah, yeah,
telling my
yeah.
family. So it took about 2 hours, and came back, and how it goes when you're sitting there, you're tight as could be. And it was first one, huge fight. Was he negligent? Yes. And then the next one was, even bigger, causation. Because I've been no cause before on
Sure. Yep,
cases.
yep.
So when they mark yes to causation, it's like, oh,
Yeah.
all right.
Yeah, we're getting something.
No, number 3.
That's right. You have a lot of
was
hurdles.
Tom, right? A lot of hurdles. Was Tom negligent? No.
Oh, wow. Yeah.
0. Got
That's
0.
amazing.
Yeah. So at that point, you're like, all right, great.
Did they have to decide on the slip if the ortho was negligent and factor his comparative in it?
No, that was, they did, but that was decided for them.
Okay,
right?
so that part was stipulated. Ortho
that was stipulated, and then they just had to do
percentage.
They just had to do the apportionment, and it came back 60-40, 60 for the ortho, 40 for the PCP.
Okay, gotcha.
Yeah.
And then how did the verdict break out?
The total verdict was 3.4 and change, about 3.5.
Was there like a wrongful death and a survival component to it? There
was, and one of the things I did in my close was with our economic, because we had Diago's old partner, Hannick. Was my economist. He did a great job, by the way.
Yeah, he was ours in March. He was awesome.
Yeah, I'll give him that plug. He did a very good job and had a very good rapport with I try to keep those guys as short as possible.
Yep.
Right? I'm sure you do too.
Totally.
But he did an excellent job. I told the jury, I said, right, because, you got the line for what he would have given to the family in wrongful death and then what he would have earned over there in survival. Just do the easy thing. Put it all in one line, right? And I said, but I do ask you, right, give me the benefit of the doubt that they didn't give Tom and put it on the wrongful death side, right? And that's what they did.
Wow.
Put the total amount on the wrongful death side.
Very cool.
Yeah.
So with that verdict, when there's no comparative on Tom, does Spencer apply, joint and several, or at least is that the argument you can make?
Mm-hmm.
Yeah, that's what I would have figured. That's amazing. Well, awesome. I'm sure the family, obviously a horrible tragedy, but
sure,
all things considered, had to be thrilled with how that turned out. And amazing lawyering. That is as crazy of a needle to thread as I've heard in a while, as Matt had told me it was. So it's really impressive outcome. Great lawyering. I know, Dallas Jr. had a ton to do with it as well.
Done.
But you obviously tried a hell of a case, and kudos to you. And kudos
Appreciate
to all
it.
the studying I can tell you've put in over the years.
Right. Look, you know how it goes. It's a team effort. So there's a lot of people,
always
a lot of people back at the office that make something like this happen. I'm sure it's the same at your office.
Yeah, and then you're the lucky one that gets to try it and get to do all the stuff afterwards. So, Patrick, was really great to talk with you. Patrick Sullivan from Dallas Hartman's office, kicking butt. I'm sure I'm going to hear a bunch more verdicts from you in the coming years, if not sooner. And I really appreciate you doing this today and sharing really a ton of great knowledge with everybody about how you did this, and just a lot of stuff that came together that I thought was really cool and resonated with me. So thanks so much for being here today, man.
Yeah, thanks for having me. I appreciate it, Brendan.
Okay.
Have a good one.
All right, you too, bud.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.